Good evening, YANCY as LOPECILlo. I'll be reciting the given assignment is posted via BBLearn, starting number 3 at the Parole Evidence Rule. Section 10, Evidence of Written Agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, as between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. However, a party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts in issue in a verified pleading. Answering ambiguity, mistake, or imperfection in the written agreement. B. The failure of the written agreement to express the true intent and agreement of the parties thereto. C. The validity of the written agreements. Or D. The existence of other terms agreed to by the parties or the successors in interest after the execution of the written agreement. The term agreement includes wills. 4. Interpretation of documents. Section 11. Interpretation of writing according to its legal meaning. The language of writing is to be interpreted according to the legal meaning. It bears in the place of its execution unless the parties intended otherwise. Section 12. Instrument construed so as to give effect to all provisions. In the construction of an instrument, where there are several provisions or parties, particular such as construction, is, if possible, to be adopted as will give effect to all. Section 13. Interpretation according to intention, general and particular provisions. In the construction of an instrument, the intention of the parties to be pursued, and when a general and a particular provision are inconsistent, the latter is paramount to the former, so particular intent will control the general that is inconsistent with it. Section 14. Interpretation according to his circumstances. For the proper construction of an instrument, the circumstances under which made, including the situation of subject thereof and of the parties to it, may be shown so that the judge may be placed in the position of those whose language is to interpret. Section 15. Peculiar signification of terms. The terms of writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have social, technical, or otherwise peculiar signification and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. Section 16. Written words control printed. When an instrument consists partly of written words and partly in printed form, and the two are inconsistent, the former controls the latter. 17. Experts and interpreters to be used in explaining certain writings. When the characters in which an instrument is written are difficult to decipher, or the language is not understood by the court, the evidence of persons skilled in deciphering the characters or who understand the language is admissible to declare the character or the meaning of the language. 18. Of two constructions which prefer. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he or she supposed or the other understood. And when different transactions of preparation are otherwise equally proper, it is to be taken which most favorable to the party in whose favor the provision was made. 19. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and other against in the former is to be adopted. Section 20. The last the under parole evidence rule. Interpretation according to usage. An instrument may be construed according to usage in order to determine its true character. Next is the testimonial evidence. Qualification of witnesses. Witnesses, their qualifications. All persons who can perceive and perceiving can make known the perception to others may be witnesses. Political or religious belief, interest of the outcome to the case or conviction of a crime, except otherwise provided by law, shall not be ground for disqualification. 22. Testimony confined to personal knowledge. A witness can testify only to those facts which are he or she knows to his or her personal knowledge. That is, which are derived from his or her own perception. 23. Disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. 24. Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases. A. The husband or the wife during the or after the marriage cannot be examined without the consent of the other as to any communication received in confidence by one form the other during the marriage, except in a civil case by one against the other or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. B. An attorney or person reasonably believed by the client to be licensed to engage in the practice of law cannot, without the consent of the client, be examined as to any communication made by the client to him or her, his or her advice given therein in the course of or with a view to professional employment, nor can attorney, secretary, stenographer, or clerk, or other person assisting the attorney be examined without the consent of the client as his or her employer concerning any fact of the knowledge or which has been acquired in such capacity except in the following cases. Furtherance of crime or fraud if the service or advice of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be a crime or fraud. Demands through same deceased client as to communication relevant to an issue between parties who claim through the same deceased client, regardless of whatever the claims are the state or in the state by individual's transaction. Breach of duty by lawyer or client as to communication relevant to an issue to breach out duty by the lawyer to his or her client or by the client to his or her lawyer. Document attested by lawyer as to communication relevant to an issue concerning an attested document to which lawyer is an attesting witness. Or joint clients as to communication relevant to a matter common interest between two or more clients if the communication was made by any of them to a lawyer retained and consulted in common when offered in an action between any of the clients unless they have clearly agreed otherwise. A physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychopathy cannot, in a civil case without the consent of the patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including alcohol or drug addiction, and between patient, his or her physician, or psychotherapist. This privilege also applies to persons, including members of the patient's family, who have participated in the diagnosis or treatment of the patient under the direction of the physician or psychotherapist. A psychotherapist is a person licensed to practice medicine engaged in the diagnosis or treatment of a mental or emotional condition. D. A person licensed to a psychologist by the government will similarly engage. D. A minister, priest, or person reasonably believed to be so cannot, without the consent of the affected persons, be examined as to any communication or confession made to any advice given him or her in his or her profession character in the course of discipline enjoined by the church which the minister priest belongs. A public officer cannot examine during or after his or her tenure as to communication made to him or her in official confidence. When the court finds that public interest would suffer by the disclosure, the communication shall remain privileged even in the hands of third person who may have obtained information, provided the original parties the communication took reasonable precaution to protect his confidentiality. Testimonial privilege. Section 25. Parental and filial privilege. No person shall be compelled to testify against his or her parents, other direct ascendants, children, or other direct descendants, except when such testimony is indispensable in a crime against that person or by one parent against the other. 26. Privilege relating to trade secrets. A person cannot be compelled to testify about any trade secret unless the non-disclosure will conceal fraud or otherwise work injustice. When disclosure is directed, the court shall take protective measures as the interests of the owner of the trade secret of the parties and the furtherance of justice may require. Admission and confession. Admission of a party. The act of declaration or admission of a party as the relevant fact may be given in evidence against him or her. Offer of compromise not admissible. In civil cases, an offer of compromise is not admission of any liability and is not admissible in evidence against the offeror. Neither as is evidence of conduct nor statements made in compromised negotiations admissible except as evidence otherwise discoverable or offered for another purpose, such as proving bias or prejudice of a witness, negative, negativing connection, contention of undue delay or proving an effort to obstruct a criminal investigation or prosecution. In criminal cases, except those involving quasi-offenses, criminal negligence, or those allowed by to be compromised, an offer to compromise by the accused may be received in evidence as implied admission of guilt. A plea of guilty later withdrawn or an unaccepted offer of a plea of guilty to a lesser offense is not admissible in evidence against the accused who made the plea or offer. Neither is any statement made in the course of a plea bargaining with the prosecution which does not result in a plea of guilty or which result in a plea of guilty later withdrawn admissible. An offer to pay or the payment of medical, hospital, or other expenses occasioned by an injury is not admissible in evidence as proof of civil or criminal liability for the injury. Admission by third party, Section 29. The rights of a party cannot be prejudiced by an act, declaration, or omission of another except as hereinafter provided. Section 30. Admission by co-partner or agent. The act of declaration of a partner or agent authorized by the party to make a statement concerning the subject or within the scope of his or her authority and during the existence of the partnership or agency may be given in evidence against such party after the partnership or agency is shown by evidence other than the of declaration. The same rule applies to the act of declaration of a joint owner, joint debtor, or other person jointly interested with the party. Section 31. Admission by conspirator. The act of or declaration of a conspirator in furtherance of the conspiracy enduring existence may be given in evidence against the co-conspirator of the conspiracy shown by evidence other than such act of declaration. Section 32. Admission by previous. Where one derives title to property from another, the other's act, declaration, or omission in relation to the property is evidence against the former if done while the latter was holding the title. Admission by silence. An act declaration made in the present within the hearing or observation of a party who does or says nothing when the act of declaration is such as naturally to call for action or comment if not true, and when proper and possible for him or to do her so may be given in evidence against him or her. For confession, the declaration of an accused acknowledging his or her guilt of the offense charged or any offense necessarily included therein may be given in evidence against him or her. Previous conduct as evidence, Section 35. Similar acts as evidence. Evidence that one did or did not do a certain thing at one time is admissible to prove that he or she did or did not do the same or similar thing another time. But it may be received to prove a specific intent or knowledge. Identity, plan, system, scheme, habit, custom, or usage, and like. Section 26. Unaccepted offer and offer in willing to pay a particular sum of money or to deliver a written instrument or specific personal property is rejected without any valid cause equivalent to the actual production on tender of the money instrument or property. That would be all. Thank you.